Well, good afternoon, everyone, again. Nigel Clayton back here again. If you've joined us already, welcome back. If this is your first session, welcome. It's the King's Chambers Property Pick and Mix. I'm Nigel Clayton. I'm a property lawyer in the King's Business and Property Group. I've been introducing the earlier sessions today. We've had four quite interesting and different sessions before. Richard Lander on witness statements, Nick Taylor on possession proceedings, Wilson Hall, quite a technical presentation on disclaimer, and Emily Duckworth just now on adverse possession, particularly after Douse. I know that after me, there is a bit of a gap. We were meant to have a presentation at 2:15 with Geraint and John Hunter, one of our planning lawyers, but Geraint's tied up in court, unfortunately. So after me, there will be a gap to 3:30 when Matthew Hall will be introducing, first of all, John Thompson, a surveyor, talking about the current state of the property market. 4:15, Eleanor Darcy with me, excuse me, back again, mortgage litigation and undue influence. And finally, at 5 o'clock, Dr. Nathan Smith on leasehold covenants. Again, forgive me if you've heard this already, but if you're new to these sessions, I should just mention that it's normally this time of the year when we hold our flagship property conference. It's usually a half-day conference, typically at a hotel. It's a good excuse really to get together and have a chat and catch up. We're hampered, of course, we can't do that at the moment. So we thought it'd be a good idea to try something different. And in fact, the format of the property pick and mix was actually Geraint Wheatley's idea, and all credit to him for this. But as I say, he's actually tied up in court at the moment, so he's not here. Finally, just a few points about the sessions. And again, forgive me if you've joined us already and you've heard this. Each session has its own Zoom login. So at the end of my session, I'll log out and that will end the session completely. If you want to rejoin for later sessions, you'll be given the details during this presentation, actually. You'll need to log in separately. I am using PowerPoint slides, as you can see. We've had a few glitches on clicking through these. I hope we don't have that today. I'm a bit reluctant to recommend questions and answers coming in. They're quite distracting, but if you've got any burning issues on Proprietary Estoppel, I'm certainly always welcome for you to email me direct. You can see my email address on the screen there. And finally, another point which has cropped up, copies of these slides, all the speaker slides, copies of our written notes, and also recordings of these presentations will be emailed out, I think on Friday or thereabouts, to all attendees. They'll all be posted on the Chamber's resources section of our website too. So there you go, that's the brief intro. I'm now left in the rather awkward position of actually introducing myself. I'm Nigel Clayton, I'm called to the bar 1987. Yeah, forget all that, you know who I am by now. Let me give you a brief intro to what I'm going to do, first of all. This talk actually follows a similar talk I gave to the Leeds Business and Property Court Forum on the 15th of October 2020. I'll actually be repeating it at the Manchester Business and Property Court Forum on the 30th of November. That's, I think, next week actually, or the week after. So spoiler alert, if you have seen this before or you want to attend the Manchester BPC Forum on the 30th of November, look away now. Those talks follow quite a helpful sort of question and answer format. I was speaking with another very able barrister plus a valuer as well, and we had questions posed by a panel. But it was a useful format. I'll try and replicate that on these sessions here. So let's make a start. Proprietary Estoppel, first of all. Some obvious initial observations. This is, these days, it's a regular feature in most property litigators' practices. It's something that we will come across either directly, being asked to bring or defend a proprietary estoppel claim, or it often crops up inferentially as another issue in a property claim or dispute. They do actually cover a whole range of circumstances. And as I go through these slides, I'll point out some of the obvious typical examples with some case law. They're also, of course, quite high value. I mean, particularly the obvious farm type proprietary estoppel claims, they are of significant value these days. I guess the problem in many ways is that the principles aren't entirely straightforward. And of course, the outcomes are uncertain. It's very much a fact-sensitive, evidence-based sort of claim. And the court has a discretion as to how it deals with it. So it's difficult aspects of property law where it's difficult to advise on and difficult to predict with any degree of certainty. So let's go through the obvious points. What is it, first of all? We always struggle with the term proprietary estoppel. It's not self-evident what it means. As I mentioned when I gave the BPC forum talk, you raise this concept of proprietary estoppel with a lay client and their eyes sort of glaze over. But frankly, for the term proprietary estoppel, just read informal acquisition of property. That's essentially what it is. It's essentially a collection of rules or principles which enables a claimant to raise what's called an equity. And I use that term on purpose, an equity, because that's the expression that's used in the cases. It just means a claim or an interest which is raised. And the court may satisfy that by giving him some proprietary right or interest, but occasionally something less, and the court has a discretion. And of course, many of the cases, claims which are partially successful only recover money, some sort of compensatory payment. Do bear in mind, it's a shield, it's a cause of action. It's not to be confused with promissory estoppel. And again, I do have this ongoing debate with solicitors occasionally who refer to claims based on promissory estoppel. And again, you have this awkward standoff in conferences where you try and explain to a lay client that it's a shield and not a sword. So it's not promissory estoppel, that's a rule of evidence. But actually, like promissory estoppel, proprietary estoppel is based on a fundamental principle of fairness. This is the sort of golden thread that permeates the whole equitable jurisdiction. It's essentially to prevent unconscionable conduct. So what are we going to look at? They're on the screen there, what the requirements are. I'll go through the key ingredients with some examples. Where do you find the law and how do you apply it? I think actually for practitioners, this is quite important. 3, is there a problem with Section 2, Law of Property Miscellaneous Provisions Act 1989? And explain why there's been a bit of certainly historical conflict with Section 2. And then 4th, I'll try and finish up with some practical pointers, some practical observations of my own. So, what are the requirements, first of all? Well, in order to raise an equity, there are essentially 3 steps. Again, I just urge a bit of caution with this. I know that the cases say that they're not to be viewed as watertight compartments, but you'll see from some of the points I'm about to make that my view is you stick to these principles carefully, otherwise you'll go astray. So, promise or assurance. The cases, the textbooks use different expressions. They say promise or assurance or an agreement or arrangement. But in fact, it can cover a whole range of representations by words or conduct by which the owner of property leads the claimant to believe he will acquire some right or interest in property. That's essentially what it is. It can range from an agreement giving rise to an informal contract. Again, I'll talk about the particular problems with Section 2 in a minute, to other forms of active encouragement. In other words, things being said or done. It can also include passive encouragement, standing by or acquiescing in conduct and leading another person to believe that by doing so, it's all right for them to acquire a right or interest. In fact, in most cases in practice, you'll get a range of conduct being relied upon. It's not just a particular promise, it's the conduct that backs it up as well. Finally, the cases do remind us that context is everything. You'll see that expression being used quite a lot in the cases, and provided it's clear enough, quote, what was meant, the conduct can be relied upon. That expression, clear enough, by the way, is Lord Walker's in Thorner and Major. I'll put a reference onto that in a minute. Second, acts in reliance to detriment. The claimant must, of course, have acted in reliance to his detriment upon the promise or assurance. Detriment can take many forms. It will typically involve some money detriment, either expenditure or doing work without proper payment, but it can include a change of position, such as typically in the farm cases, foregoing educational or career or other opportunities. Do bear in mind that the extent of the detriment required often has to be weighed and valued, with credit being given for what are called countervailing benefits. And it introduces another awkward and difficult weighing exercise when looking at this cause of action. Finally, 3, there is this overall test of unconscionability, which ought not to be overlooked. It must be unconscionable for the owner to deny the claimant's claimed interest. And in practice, this is where the court stands back and it weighs the evidence in the round. It will look at the overall positions of the parties, the nature and extent of the promises or assurances, and the nature and extent of the detrimental reliance. But essentially, if you can establish those 3 key requirements to raise an equity, you then look at stage 4, how does the court satisfy that equity? And again, this is it introduces another difficult aspect about the scope to award discretionary relief. The courts have said frequently that the aim, in fact, is to achieve the minimum equity to do justice. I think as you look at the way the cases have moved on, that tends to underplay what the court's trying to do. It's not just finding that necessary minimum. The more recent cases, and I'll point you to some in a second, tend to show that the court's approach is to achieve proportionality between the detriment and the remedy. In other words, a sort of a moderating, balancing exercise. Let's look at some examples. I'll give you 4 examples. No apologies, first of all. There are a lot of farm cases, and I was quite staggered when I did some research for this. I remember when I was first starting out in practice was this case of Ree Basham, deceased, 1986. That's a classic farm reliance case. But there are a lot of other cases too, and they're on the screen. And the farm cases generally follow pretty much the same format. So you've typically got a father telling his son, again, by a range of words and conduct. And believe me, the cases show that often these cases hang on very little. That one day the farm will be his. One day, son, this will all be yours. Son leaves school, he forgoes higher education. He works on the farm for a substantial period of time, often on reduced or no wages, and he forgoes other employment opportunities in the expectation that he will acquire the farm. Now, that's the sort of general gist of the farm cases. The significant feature is, and it's apparent from some of these cases, that the claim can be made during father's lifetime. So this is a prospect of father transferring or ridding himself of his farm assets during his lifetime in breach of this expectation. He can be restrained. And as I say, quite a few of these cases that you'll see on the screen demonstrate that that the court's jurisdiction during the lifetime of father to make appropriate provision. A lot of cases there, and you'll see a lot quite recently too, in fact. And I've got copies of them all. I've gone through them all. The significant feature possibly is that to a greater or lesser extent, in all of the cases, the claims were successful. That is, to a large extent, the claimant did recover some property or some asset in the farm. I don't think, from recollection, I think there may have been some adjustments or partitions in one or two cases, but from recollection, none of the claims were actually rejected. Just bear in mind as well that often with these farm cases, you get, of course, the consequential dispute about dissolution of farming partnerships. So you often have to wear two hats, your property lawyer's hat and your partnership lawyer's hat. Other examples, typically in co-ownership cases, these are typically boyfriend and girlfriend or husband and wife sharing property. And of course, the claims are often framed in proprietary estoppel, either with or in place of the constructive trust claims, the common intention constructive trust claims. Yaxley and Gotts is a classic example of that, and it points out some of the sort of competing features of the two jurisdictions, but it's a common feature of those co-ownership cases. It's arisen in what I call the development or the joint venture cases. And again, Cobb and Yeoman's Row, Lord Scott's decision, of course, is a classic example where it actually fell short of being giving rise to a proprietary estoppel recovery. But it can crop up in other cases. And again, this is where, as a property lawyer, you need to have your sort of antennae switched on to the reach of proprietary estoppel. And I certainly see in proprietary estoppel being relied upon in boundary agreement disputes, agreement to adjust a boundary and acts in reliance, building works, etc. And finally, you can get the proprietary estoppel claims to other proprietary rights or interests too. So you could even, and I've had this as well, a proprietary estoppel-based claim to an easement. Again, a representation or an assurance, which might in fact give rise to an equitable easement, that's supported by sufficient acts in reliance to detriment. So again, a range of things there to keep on top of. Stage two, where do you find the law? Well, I mentioned already that there's a lot of law out there, and the cases and the textbooks contain frequent dicta or comment to the effect that this is a flexible, equitable remedy. The doctrine cannot be treated as subdivided into 3 or 4 watertight compartments. The overriding consideration is one of unconscionability. My advice, forget that, frankly. I've seen so many claims go astray because the lawyers don't really deal with them in a principled and structured way. I think Lord Walker said in Cobb and Yeoman's Row, it may be a flexible doctrine, but it's not a sort of joker or wild card to be used whenever the court disapproves the conduct of a litigant. It must be formulated and applied in a principled and disciplined way. And that applies as much to judicial fact-finding and decision-making, because Lord Justice Lewison said in Davis and Davis, 2016 decision, and you'll see the reference on the screen, the court has to exercise a broad judgmental discretion, but it must be exercised on a principled basis. He said the judge doesn't have what His Honour Judge Weeks QC once famously said in Taylor and Dickens, a judge doesn't have a portable palm tree to do justice as he wants. So my firm practical advice, frankly, based on my experience, is stick to McGarry and Wade like glue. I've given the reference there, McGarry and Wade, Law of Real Property, 9th edition, chapter 15. I should just, in passing, mention one thing about McGarry. And a solicitor friend of mine asked whether I was going to include in this presentation some of the gags that I included in the Leeds BPC presentation. And I am denied about them, but I'll include them. They're not actually gags, these are true stories. Sir Robert McGarry, way back in 1986, I had the rather dubious honour of being in the Observer National Mooting final, and at the celebratory dinner at the end, I was strategically positioned with Sir Robert McGarry on my right and his wife, Lady McGarry, on my left. Like chalk and cheese, he was as dry as Tito and Waddell, and she was as happy as a fruit and nut cake. But I always remember Sir Robert McGarry, apart from asking me to make sure I bought McGarry and Wade every edition, he actually said to me, and I was just about to start bar school at this stage in 1986, he said, if you aspire to practice at the Chancery Bar, you need to lose your Yorkshire accent. Never forgotten that. That's McGarry for you. So you find the law in McGarry and Wade still. Two leading cases, Gillette and Holt, Thorner and Major. But the best summary, and the one that in fact appears quite regularly in the recent decisions, it's the one the courts tend to refer to, is quite a succinct summary of the principles given by Lord Justice Lewison in Davis and Davis 2016 Court of Appeal. So you've got the reference there. Let's move on to stage 3. Is there a problem with Section 2 of the Law of Property Miscellaneous Provisions Act 1989? I begin with the obvious point. Section 2, of course, requires a contract for the sale or other disposition of land to be in writing and signed by the parties. Significantly, without that, you don't have a contract at all. Before that, we had, of course, Section 40 of the Law of Property Act 1925, and I appreciate this is going back quite a few years. The law permitted enforcement of an informal agreement, which was either evidenced in a note or memorandum in writing, or supported by part performance. Now, in practice, part performance was very much like proprietary estoppel. So you often had these sort of two claims being run in tandem. And again, just pausing there, I remember one of my first ever cases down at the RCJ in London. Again, it must be probably the early 90s. And it was picking up on a case that straddled the boundaries of Section 40, part performance and proprietary estoppel. It was before a judge called Mr. Justice Harman. And for the older ones who are watching this, he was like the hanging Judge Jeffreys of the Chancery Division. I recall we reached a point during this case, he actually turned to me, I was very junior at the time, he turned to me and actually said, Mr. Clayton, do you know what proprietary estoppel actually is? Which I took that as a sort of a compliment at the time, but I actually decided to bottle it by saying, not really. And of course, he then left me alone and concentrated as far on my opponent. So, good bit of advice there. If you don't actually know what you're doing, just say so. And you seem to get home on that. The point is, though, that Section 2 is much stricter. As I say, without the formalities, you don't have a contract at all. There is an exemption, of course, in Section 2.5 of the Law of Property Miscellaneous Provisions Act. It says, nothing in this section affects the creation or operation of resulting, implied or constructive trusts. But of course, it doesn't mention proprietary estoppel. So that then led Lord Scott in Cobb and Yeoman's Row at 2008 to say that you can't then rely on proprietary estoppel to render a void agreement enforceable. What he actually said, and I quote, equity can surely not contradict the statute. So that's where the problem arose, that you couldn't sneak in proprietary estoppel to enforce an informal agreement that was otherwise void for compliance with Section 2. That's the problem. As a result, of course, practitioners then tried to shoehorn proprietary estoppel claims into constructive trust claims. I mentioned this already, and Yaxley and Gotts is an example of this. But in fact, when you read it, Lord Scott's comments are only obiter. I think he actually said that it wasn't necessary to decide the point in that case, which of course is the judicial get out of jail card. So it's an obiter point only. And again, just pausing there, my final story on this, I remember I did once have a very close call with Lord Scott. He was then Sir Richard Scott, the Vice Chancellor of the County Palatine of Manchester. Again, this must have been in the early 90s. I was crossing the road across Deansgate, just between Bridge Street and John Dalton Street, which incidentally is the most dangerous traffic spot in the whole of Manchester. I wasn't looking, I stepped out and the judicial limousine cruised past me and ran over my right foot with Lord Scott in the back, looking very much like the Queen Mother, just waving at me. I shall remember catching up with him at Bar Mess sometime later, and I pointed out this. Do you know what he said to me? He said, "Nigel, equity aids the vigilant." And in that moment, I knew why he was a High Court judge and I was just a jobbing barrister. So that's Lord Scott. That's the Section 2 point. The answer is, of course, and if you look at the textbooks, McGarry and Wade, and even Lord Newberger in Thorner and Major, that in fact Section 2 only regulates contracts. It doesn't regulate the enforcement of an equitable remedy, which is based on informal arrangements. So the bottom line is, no, I don't think there is necessarily a problem with Section 2, but there may still be some scope for friction where what you're actually seeking to do is enforcing what would otherwise be an arm's length legal contract that for some reason has gone off. So just keep that point in mind. There is a bit of a potential problem there still. Some practical pointers. Finally, I make the obvious point that, of course, each of these cases is fact sensitive, particularly so. And I think this is what makes them, in my experience, quite difficult to sort of manage. And it reminds me really why I never became a family lawyer, because certainly in these sort of personal, domestic sort of proprietary estoppel disputes, you're almost certainly going to be burdened with years of family strife. And it means sifting the evidence, weighing it, but also, putting your sort of judicial detective hat on to find that nugget of evidence that's going to get you home. So the cases depend on evidence. I've mentioned already, sticking to McGarry and Wade like glue, please, please, please always structure these claims in a principled way. I mentioned don't get blurred vision. As I say, you're often overwhelmed by a mass of evidence and a mass of conflicting evidence. I've always found it quite a useful discipline to be able to, if you can, actually list the key ingredients on a sheet of paper. What are the representations? What are the acts in reliance to detriment, possibly the countervailing benefits, and comments on unconscionability? If you can't reduce them in that way, then you probably will get blurred vision and really not see the wood for the trees. Do weigh cost benefit throughout. This goes through any litigation, of course, but particularly so with proprietary estoppel claims. You may well, as I say, get mesmerized by the end game of recovering a property and substantial value, but do weigh up the costs and risks of proceeding to that point. I've put a reference to expert evidence. I've got to say I'm in two minds about the value of expert evidence in these cases. When I did the Leeds BPC forum, the judges there, I think it was His Honour Judge Davis White, was very keen that we promote the use of experts, not just at trial, but also as a means of providing early advice and assistance. And it's certainly a fair point to note that experts can provide not just valuation evidence, they can advise on possible partitions of land. So in the farm case, is it possible to achieve a sensible, cohesive partition of farmland, or the farm business, for example? One or two of the cases, incidentally, do show that they are also used to help weigh and value the benefits on the countervailing benefit scale, and particularly things like weighing the actual sort of extent of the detriment suffered by a young farmer in terms of wages against market wages for a farm. I think final 2 points. As I've said already, you've probably got the gist of it. Advising on merits, evidence, and quantum is really difficult. you've got to factor in so much room for manoeuvre in not just assessing the likely strength of the evidence, which can turn on a witness's recollection. So it's inherently difficult to rely upon, but also factor in the scope for judicial discretion. What may seem to you unconscionable may not seem to a judge unconscionable. And how the judge then achieves or how he satisfies the equity, what award he gives, creates tremendous scope for discretion effectively. So you're going to have to weigh all these things up and factor in room for manoeuvre. Finally, again, this was pressed at the Leeds BPC. I'm not a fan of mediation. I think they're frequently misused and don't achieve the objective they were designed for. But I have to say that given all the practical issues and problems that I've flagged up already, I do take the view that, given the cost risks, that proprietary estoppel claims, I think, are ideally suited to mediation. So if there's scope to frame a claim and defend it, then there must be scope to bring parties together, possibly with an expert to assist in trying to achieve a cost-effective and viable settlement. I think bang on time, brilliantly for me, that was really all that I was going to say on proprietary estoppel. As I mentioned before, if you want a bit more on proprietary estoppel, do make inquiries about the Manchester Business and Property Court Forum, which I think is about 5 o'clock on the 30th of November, so a week after next. And you're welcome to join that too. You may get some more out of that. But otherwise, that's it from me. I'm not going to turn up the Q's and A's. If you've got any particular queries at all, by all means, just send them through to me. You've got my email address there, nclayton@kingschambers.com. So I hope that's been a useful session. I think session number 5. Just a reminder, there's a bit of a break now. We're back on again. Matthew Hall's introducing the final 3 sessions. 3:30 to 4, John Thompson looking at the property market. He's a surveyor. 4:15 to 4:45, I'm actually billed as the guest speaker with Eleanor Darcy, one of our busy Chancery and commercial litigators. She's going to talk about mortgage litigation and undue influence. And then 5 o'clock, finally, it's Nathan Smith, our resident rocket scientist. He's talking about leasehold covenants. So 3 more to go. I hope they've been enjoyable. As I say, the slides, the notes, and the recordings will all be made available. But otherwise, thank you very much indeed.